Hey everyone, today we are diving into the topic of renunciations in the context of a grant of probate. Whether you're an executor, a family member, or just curious about how probate works, this video is for you. We will explore what renunciations are, why they are sometimes necessary, and the legal provisions under Singapore law. Let's start with the basics. When someone dies leaving a will, the executor named in the will is responsible for carrying out the wishes of the deceased. This involves applying for a grant of probate, which gives them legal authority to manage and distribute the estate. But what happens if the executor named in the will doesn't want to take on this responsibility? That's where renunciation comes in. Renunciation is the legal process by which an executor formally declines the role. In Singapore, this is governed under the Probate and Administration Act. Under Section 3 of the Probate and Administration Act, an executor may renounce their right to act as an executor of an estate. This usually occurs if the executor feels unable to fulfill their duties, whether due to personal circumstances, conflicts of interest, or simply a preference not to take on the role. To renounce the role, the executor must complete a formal renunciation document. Once filed with the court, this document confirms that the person will not seek to obtain probate or administer the estate. Most importantly, under Section 5, renunciation is a final decision. It cannot be withdrawn. Now, you might be wondering, what happens after renunciation? If the named executor renounces, the next person in line, whether another executor named in the will or beneficiary, can apply for the grant of probate. Let's look at some practical scenarios. An executor might renounce because they live overseas and find it difficult to manage the estate from afar. Or perhaps they feel that another executor named in the will is better suited for the role. Renunciation allows for a smooth transition without the delay or confusion of an executor neglecting their duties. Once renounced, the executor is released from all duties associated with the estate. However, it's crucial to note that if an executor has intermeddled, that is, they have already begun to act on behalf of the estate, they cannot renounce. This ensures that no partial decisions or actions are taken without accountability. So to sum it all up, the relevant law governing renunciations in Singapore is Section 3 to 5 of the Probate and Administration Act. And number 1, renunciation is a formal refusal by an executor to act. Number 2, a renunciation must be done before any intermeddling occurs. Number 3, once renounced, it is final. Number 4, another person can then apply for the grant of probate once the executor renounces. So if you're an executor considering renunciation or you've been affected by this process, it's always a good idea to seek legal advice to understand your options. Until next time, stay informed and take care.